Hello, Rumblers. It looks like there is pretty bad news for Second Amendment rights activists, but we're going to be covering it coming out of Florida for cannabis users who might be looking to purchase a firearm. This information reflects on the Hunter Biden situation, and it sounds like Joe Biden recently spoke about it. Let's find out. Stick around, hit that Rumble button, subscribe, and stay tuned. First story I wanted to start out with tonight to get a discussion going is this came out the midterms were well underway, so I understand why not a lot of commentators have been speaking about it. However, it came to my attention and I wanted to get a little bit more publicity to it, so I'm going to talk about it. As you can see here, a federal court dismisses a Florida Attorney General Commissioner's lawsuit on medical marijuana patients' gun rights. This is post Bruen. So it's going to be one of our first chances to look at a district court's analysis of Bruen and what that might look like at the trial level in upcoming cases, as well as we already know that many states following Bruen passed laws that are potentially going to be running up against it. However, I suspect, and after we learn more about this case, you might as well, that in fact there is not going to be much pushback from the courts, and that this test will be mostly a win in name only and not much of a victory on the ground for gun rights of Americans. So let's get started just reading a little bit of preliminary information here. A federal judge on Friday dismissed a lawsuit from Florida's agricultural commissioner that challenged a ban on medical marijuana patients' rights to buy and possess firearms. The case has extended over months, with attorneys for Commissioner Nikki Fried. Some people may be familiar with that name. She was an up-and-coming starter with Ron DeSantis, arguing that the federal firearms ban for patients is unconstitutional. And effectively, her argument is going to be that if we aren't going to enforce the restriction on the possession of firearms for drug users, i.e., see Hunter Biden, then we should say so, and we should allow our medical marijuana license or registrants to obtain a firearm without worry that the federal government might attempt to enforce a hefty, I believe, 15-year sentence. But we will dig in a little bit more. Here we can find out, but while Fried expressed optimism following the oral arguments, citing her legal team's compelling performance, a U.S. District Court for the Northern District of Florida judge ultimately disagreed, saying in a 22-page opinion that the plaintiffs have standing, but that their claims fail on the merits. The gist of the Judge Alan Windsor's ruling is that he sided with the Justice Department's arguments that people who use marijuana, regardless of state law, are engaging in criminal activity at the federal level, and therefore there's precedent to deny them the right to have firearms. So here we are going to read that the judge twisted himself into a knot to effectively argue, because under Bruen, he now has to look to the historical context as opposed to any sort of modern understanding of the Second Amendment. And so in able to do this, if you look at history and the enactment of the Second Amendment, cannabis was actually not a prohibited substance. And actually many of the founding fathers grew cannabis, or most likely hemp at that time, such as Thomas Jefferson. And with that, if you look at that through the historical lens of cannabis use and the Second Amendment, the only historical conclusion you can come to is that they really weren't concerned about cannabis use. However, this judge is very clever, and this article points it out, to frame the entire issue as cannabis use is a criminal act at the federal level. Historically, criminals aren't allowed to have Second Amendment rights. Now, that's a really interesting conclusion there, because yes, historically, criminals aren't allowed to have Second Amendment rights, but under that, any unenforceable federal law, such as the cannabis ones, or the ones that are being unenforced currently, effectively under this judge's ruling, Hunter Biden the law should be enforced against him. He's a criminal and shouldn't have had possession of the gun. Now, it's really interesting to see why this lawsuit was brought. I wonder if it was to try to set precedent for that or for such future cases that may come. As previously, generally speaking, Second Amendment rights have been completely curtailed to anyone who was under the Controlled Substance Act in violation as a criminal. Because the historical argument being that history has never allowed criminals themselves to do this. However, I think instead of focusing on whether it's a criminal act or not a criminal act, as almost anything it can become a criminal act by the passage of a law, we should truly take a look at history and find out whether the specific act here, cannabis consumption, was a prohibited act that would get you basically on a red list for firearms purchases. And I've got to say, I don't know if there is any history in the books that says that someone who used cannabis when the Second Amendment was passed would have been prohibited from having a rifle. But it's an interesting perspective. We can look a little bit closer at the details here as we pull up the order for you guys. And I will read some of the highlights here. So to start off, we get a little opening background. Federal law prohibits certain people from possessing firearms. Among them are convicted felons, fugitives from justice, and relevant here, anyone who is an unlawful user of or addicted to any controlled substance. Cough, cough, Hunter Biden. Please. As the parties agree, Florida's medical marijuana users are unlawful users of a controlled substance. So this law makes it a crime for them to possess firearms. The primary issue in this case is whether the Second Amendment allows this result. This is him intentionally starting that framing, describing it as medical marijuana users are criminals, and does the Second Amendment allow criminals guns? It's really easy to answer that question when you frame it like that. However, I don't think he's actually looking at the historical context of the act itself, cannabis use. He's looking at the historical context of criminal acts. So first he has to make that parity between cannabis use and criminal acts before he can do that. And so he goes along this line and says this. We're going to get a little bit more background first. In 2016, Florida stopped criminalizing the medical use of marijuana. Many people refer to this change as Florida's legalizing medical marijuana, but Florida did no such thing. Under the Supremacy Clause of the Constitution, state laws cannot permit what federal law prohibits. However, is the Controlled Substances Act actually a valid federal law? Sorry, tangent on me. Let me jump out of the quote here. Personally, I'm not sure the Controlled Substances Act is actually a constitutional law in the first place, as it's passed under the Interstate Commerce Act, alleging that all drug commerce goes through interstates. It's the same reason they think they have the right to control guns at the federal level, even though it's a state issue as well. Montana is a state that's been fighting it, at least on the gun front. Anyways, continuing on. Under the Supremacy Clause of the Constitution, state laws cannot permit what federal laws prohibit, unless that federal law is unconstitutional, cough, cough. And federal law still prohibits possession of marijuana for medical purpose or otherwise. Indeed, federal law designates marijuana as contraband for any purpose and prohibits entirely its possession. So while Florida, like many states, almost all the states at this point, including the territories, it's getting absolutely hilarious that the federal government is behind the wagon here, when almost every state that the federal government supposedly regulates has already allowed it in some form or another, even if it's just a low THC medical variant. And the federal government's even allowed hemp already under the 2018 Farm Bill. Anyways, moving on. Thank you, Trump. That was one thing that happened under his administration that was worthwhile. So while Florida, like many states, has decided it will no longer criminalize medical marijuana, the simple fact is that anyone in any state who possesses, distributes, or manufactures marijuana for medical or recreational purposes is committing a federal crime. And this has been held pretty consistently across the board in previous cases, which is why he has things to cite to. Typically, these aren't necessarily focused on marijuana either. Sometimes these cover other drugs under the Controlled Substances Act nonetheless. As anyone driving by Florida's many marijuana dispensaries can see, though, federal law is not always enforced. In fact, through a series of appropriations riders, frequently called the Rohrabacher-Farr Amendments, wow, that's going to be a tough one to pronounce. Try that one 3 times. Congress has prohibited the Department of Justice from spending funds to prevent states' implementation of their own medical marijuana laws. So Congress has precluded the Department of Justice for now from prosecuting crimes that Congress, for now, chooses to maintain on the books. And this is why I said I think they need to look at the historical context of the act itself, not something that, for now, is ruled one way by Congress. Explaining that the federal government's current approach is a half-in, half-out regime that simultaneously tolerates and forbids local use of marijuana. This sounds much like selective enforcement, which means we're going to get partisan enforcement. And we're going to talk about that coming up here. As I've been hinting to over and over again, Hunter Biden is the perfect example of this. And where truly our institutions are going to start falling apart when more and more enforcement is purely based on the politics of the matter. But let's go ahead and continue on in describing who these plaintiffs are. And how they're related to the situation. So 3 plaintiffs want to participate in Florida's medical marijuana system while possessing guns, but as things stand, their use of medical marijuana, their, quote, unlawful use of a controlled substance, end quote, makes any gun possession a felony punishable by up to 15 years in prison. So that's the 15-year timeline we were talking about as a potential punishment. Now let's see if Hunter Biden serves 15 years in prison for potentially, I guess he didn't commit this crime. Well, yes, he did commit this crime and he lied about it. So it would also be fraud on top of that. Let's see if he's held accountable for that. That is the situation plaintiffs challenge. They contend that this violates their Second Amendment right to keep and bear arms. They contend a federal firearms prosecution would violate the Rohrabacher-Farr Amendment. So let's find out who the plaintiffs are. The plaintiffs are Florida Commissioner of Agriculture Nicole Freed, the commissioners who she'll be referred to from here. She is someone that many people might be familiar with already as a large character in Florida politics, and 3 individuals who want to use medical marijuana and possess guns. So these are just going to be 3 citizens that want to possess guns. They're currently in the medical marijuana registry. And as we'll see, the defendants are Attorney General Merrick Garland himself, our favorite Attorney General, one of the most corrupt Attorney Generals, as he tries to lock up school moms who are trying to change school board results. Nonetheless, continuing, the director of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, the ATF, and the United States. The United States and the ATF enforced the criminal laws at issue, and the ATF promulgated the regulation defining an unlawful user. ATF also created the form mentioned above. This is the one that Hunter Biden had also signed and went ahead and frauded that as his memoirs. We'll discuss later. The form does ask if the transferee is an unlawful user of marijuana, and it warns that the use or possession of marijuana remains unlawful under federal law, regardless of whether it has been legalized or decriminalized or medicinal or recreational purposes in the state where you reside. Plaintiffs brought 4 counts. The first 2 are seeking declaratory and injunctive relief based on the Second Amendment. The next 2 counts are actually based on that Rohrabacher-Farr Amendment, which we can discuss a little bit more detail, but I'm going to focus on the first 2 and the Second Amendment here. Now, the procedural posture that we found ourselves in and why we're here, I suppose, and where we are in the stages of litigation. This is going to help us figure out what standards are applicable. So defendants move to dismiss the contending that the plaintiffs lack standing and have not stated a claim for relief. So this is going to be a 12B6 motion for a failure to state a claim, as well as saying that they don't have standing altogether. Now, the courts went ahead and had a hearing on this, oral arguments as well, and they've come to the conclusion that, of course, there is standing with these facts, but let's go ahead and say that they lost on the merits. They're unlikely to succeed on the merits, so they have a failure to state a claim. They didn't get to the conclusion of summary judgment. However, they did dismiss it altogether. Let me get to some relevant parts here. As they're discussing the Second Amendment precedent, let's see under what Bruen, the new analysis looks like. So the Second Amendment guarantees the individual a right to possess firearms. Judges, scholars, and others have long debated the extent of this right, and many questions remain unresolved. But the Supreme Court recently clarified that the government cannot restrict the Second Amendment right unless the regulation is consistent with this nation's historical tradition of firearm regulation. So that's where we're going to see that Bruen citation. That's the real test right there. The regulation is consistent with this nation's historical tradition of firearm regulation. And this is where he creates a very simple question. Marijuana is crime. Historical tradition of firearm regulation has never let criminals have firearms. Answer, simple. This is the dispute I have. But let's listen more to his analysis. It is not enough to simply posit that the regulation promotes an important interest. Plaintiffs' base Second Amendment theory is straightforward. They contend that keeping guns from medical marijuana users is not consistent with any historical tradition of firearm regulation. The government's twofold response is equally straightforward. The government first contends that we need not explore historical traditions because the Second Amendment protects only law-abiding, responsible citizens, not federal drug offenders. So that is putting the cart before the horse if I've ever seen it. And typically that's meant to rule people who are outside of the Second Amendment protections. However, when you are a law-abiding citizen who has not been convicted of a crime, because someone who is participating in the medical program may be violating federal law, but have they been convicted of violating federal law? Are they an unlawful citizen, or are they potentially an unlawful citizen after you've proven in a court of law that they're guilty beyond a reasonable doubt? Until there's been a hearing that they're guilty beyond a reasonable doubt, then none of these people are unlawful citizens. But as we see, the court buys into the government's arguments, declares them unlawful citizens, and unlawful criminal citizens do not get Second Amendment protections. It's really that simple, folks. I wish there was a better solution. I wish that judges would be able to analyze this with a little more forethought. Hopefully this ends up getting appealed. I believe there may be some more political motivations occurring behind the scenes that we aren't seeing. And finally, I'm going to go ahead and read the judge's conclusion. And let's keep in mind, this was on a motion to dismiss, a 12b6 motion, not summary judgment. So in conclusion, the judge states, as a matter of law, enforcement of the challenged laws does not violate the Second Amendment or the Rohrabacher-Farr Amendment. The government's motion to dismiss is granted and plaintiff's claims are dismissed. I need not reach the government's alternate request for summary judgment, and I have not considered the scholarly articles and other materials the government submitted in support of that alternative request. The clerk will enter a judgment that says plaintiff's claims are dismissed on the merits for failure to state a claim. The clerk will then close the file. And so that was ordered on the 4th as the midterms were really in full swing. So I understand why it wasn't really reported on, but I did feel like this is an important first look at what judges might do under the Bruen precedent. I don't think this will be upheld if it were to be challenged, especially if it were to make it to our current Supreme Court. However, I don't have much hope for lower courts to support many of these things, and we're likely to see anything that wants to have their constitutional rights actually protected will have to have the support and funding to likely take it to the Supreme Court, or at least the hope that they live in a area that has courts that are more well-reasoned. And with that, I want to highlight a couple other news stories that go perfectly with this. Just recently, Hunter Biden made the news as the consequences that Hunter Biden could face for violating arbitrary gun laws should give his father pause. No doubt, I 100% agree. In an interview with CNN's Jake Tapper yesterday, President Joe Biden conceded that his son Hunter lied on a government form when he purchased a handgun in October 2018, a federal felony punishable by up to 10 years in prison. So that's with the lying there, as well as the admitting to drug use and being in the possession of a firearm if they're capable of proving those things happened at the exact same time. I'm not exactly sure what is in his 2021 memoirs, Beautiful Things. However, if they are, that would be a total of 25 years. But let's go ahead and see what Joe Biden had to say and how informed our president is on the issues.
His problems and was straightforward about it. I'm proud of him. He came along and said, by the way, this thing about a gun, I didn't know anything about it, but turns out that when he made my application to purchase a gun, what happened was I guess you get asked, I don't guess, you get asked the question, are you on drugs, you use drugs? He said no. And he wrote about saying no in his book. So I have great confidence in my son. I love him, and he's on the straight and narrow, and he has been for a couple of years now, and I'm just so proud of him.
He sure did. He came out and he is just proud of his boy breaking laws while his attorney general goes ahead and argues for those same laws in federal court and not allowing otherwise law-abiding medical cannabis licensed individuals from having a firearm. But his crackhead son is more than capable of having a firearm, which is probably why he disposed it next to an elementary school in a dumpster, or it might have been, I believe, his whoever he was sleeping with at the time, let's say. And with that, we will go ahead and end out the stream. I'd love to hear your guys' thoughts on the new gun cases that come out. I want to know what you guys think about the new Bruen decision. Whether that history and traditions analysis will actually hold up and protect some individual Second Amendment rights. Put your comments in the bottom. I don't think courts will have the guts to stand up for Second Amendment rights, especially with rising violence that's occurring. But what do you guys think? Let me know.